Hello, I'm Len, the host of Targeted Justice v. Garland, a podcast about the extraordinary lawsuit. It's been a while since we have been able to record a podcast, and today we have a very important episode with the most current update regarding our main lawsuit. With me today, as always, my co-host, a woman who made it all happen, unstoppable attorney for the plaintiffs in Targeted Justice v. Garland, Anna Toledo. Please say hello to our viewers, Anna.
Hi, everyone, and hi, Len. I'm so glad to be here. Thank you.
That's great. So am I. Before we start, I want to remind our viewers that Targeted Justice v. Garland is not the only lawsuit filed by Targeted Justice. For more information about our second lawsuit, I would like to refer you to an episode in which we discussed the legal case, and I believe it's called Lawsuit Number 2. And I know a lot of people have been waiting for an update and what's going on with our main legal case, so let's not let you wait any longer. Here we go. This is an update from the U.S. Court of Appeals for the Fifth Circuit for Targeted Justice v. Garland case. Let's get to the point. On March 8th of this year, a panel of 3 judges of the Fifth Circuit issued a summary calendar in which they agreed with the district court decision. In this document, this panel issued an opinion dismissing the appeal on jurisdictional grounds, holding that all of the orders that the plaintiffs appeal are interlocutory and unappealable. I have a question to you, Anna, about both of these statements. First of all, it's not a decision, it's a summary calendar. What's the difference? Why wouldn't they just issue an opinion? And the second one, unappealable, I don't understand the meaning of this word, because anything can be appealed. Please educate us, Anna.
What the summary calendar did was that they did not set the case for argument. They issued an unpublished opinion. Unpublished opinions do not create precedent in the court. So that's really what they did. They just precluded the oral argument that we had asked for. Then the second thing, the interlocutory, is usually for a decision to go to the Court of Appeals. It has to be a final decision on the merits. In this case, it was a final decision because the court dismissed, and not only dismissed, but dismissed with prejudice. That's what we're arguing, right? That was nothing left. The district court provided that, we'll put this on an administrative hold for plaintiffs to exhaust the administrative remedies. The administrative remedies, we argue, are no longer necessary because remember those Privacy Act requests that we all made to find out the TSDB status of people. But once you're in litigation, you don't need to go through an administrative procedure of Privacy Act because that's what discovery is about. So that's part of the things we're arguing, that there was a final decision because the court dismissed with prejudice all the claims against defendants.
No, I understand now. And I remember the type of response that we received from the FBI. It's something called the Glomar response, when they can neither confirm nor deny. And this is their final answer. So this argument simply doesn't work. Yes, we have exhausted all the administrative remedies.
Yeah, and furthermore, first of all, they're not going to change the Glomar response. We know that. Second of all, even in litigation, they are denying the right to discovery because that's one of the issues that we filed a motion to compel limited discovery regarding the TSDB status of the plaintiffs. And even then, even in a litigation, the FBI said we're not going to give the information. So, it's an exercise in futility, and the Fifth Circuit has said, and number one, when something involves constitutional rights, you do not have to exhaust administrative remedies. So when you have an agency calling you a domestic terrorist, and you're not a terrorist, and it's false, and it's distributing it through the nation, you have huge irreparable harm there going on, and you don't have to exhaust remedies while they continue defaming you. That's part of our contentions.
Thank you, Anna. Let's go to the next slide. So that doesn't stop you from acting in the U.S. court, and you filed a petition for rehearing en banc on April 5th of this year. For those who are not familiar with the judicial lingo, en banc means all the judges in that court have to make a decision. It will come to everybody's desk, and we're asking for all of them to review it. Before we go any further, I noticed there's a new section in your petition, and that's other interested parties identified. I think this appears for the first time. Am I correct?
Yeah, that's correct, because as you may recall, when we submitted our brief originally, we put the certificate of interested persons. That's a requirement of the Fifth Circuit. You have to put the names of people and corporations that might have a financial interest in the outcome of this case. Why? Because the judges have a duty to check if they have a conflict of interest because of a prior client. So in this case, the government, even the individual capacity defendants, they said, we don't have to name any interested parties because we're the government. It is our position that when there are individual capacity defendants, they have to put the names of the individual capacity defendants because they have a financial stake in the outcome of the case. And then there are corporations that we know have closely worked with the program. And so that the ones that are listed here are the ones that we have the evidence that they, in fact, financially benefit from the operation, from the continuing of the program. So that's why, you cannot put here and just anything. You have to place the names, put the names. You have to be honest and candid with the court and put the names of those entities and people that that have a financial stake in the outcome of this case. And then also I put in there Mr. Glasheen because, as you may recall, Charles Cable retired from the FBI 2 weeks after we filed the lawsuit. And then the man that substituted him, his name is Stephen Glasheen. Well, under the federal rules of civil procedure and appellate procedure, defendants were supposed to substitute Mr. Glasheen for Mr. Cable, but they haven't done so. So I include him there as well because he's the current director of the Terrorist Screening Center, and as such, he has a stake because he might even, continue with his personal liability for refusing to remove from the TSTB the names of innocent Americans that are on this list.
Yes, I remember that scandalous story when we found out that within days of filing our lawsuit, Mr. Cable submitted his resignation, but the government defendants have never acknowledged his substitute, Stephen Glasheen, is a part of this lawsuit in any shape or form. So that was pretty despicable. And I see very familiar names on this list, like Infraguard Citizen Corporation, Leidos, Lockheed Martin. Do you explain anywhere why you put these names on the other interest parties list, or it will be left for the discovery?
Yeah, it's not required. It's not required that I explain to the court because the court relies on my professional judgment that what I put in there is correct. And everything I put in there is because I have the evidence. I wouldn't put there a name of a person or a corporation if I didn't have the conviction that, in fact, they do have a financial stake in the outcome of this case, which is, ultimately in the shutting down of this program.
Absolutely. Now let's go to the petition itself. First of all, I want to tell everybody that as I was reading this petition, I I drop a few tears because the your writing, Anna, is so inspirational. It is so precise. The more you work on this case, you come to a point when you distill the issues to the point of clarity that it requires, and I was just blown away, Anna. So thank
Thank
you for this work. I want to cite you. I express a belief based on a reasoned and studied professional judgment that the panel decision attached as the appendix of this petition warrants en banc review under both the Rule 35 criteria. Can you tell us a little bit about this Rule 35?
This is a required, the procedures in federal court, particularly in the Court of Appeals, are very structured. And one, in order to petition the court, it's like, in order to bother these very busy judges, you have to make a representation that you're not taking their time just, as a whim, you have to make the representation under your signature that you have a belief that there is a reason why the full court should look at this decision and reverse it. One of them is because it goes against the Supreme Court or the Fifth Circuit precedent. And the other criteria, there's two, it's either or, but in this case, I allege both are met, or because the case presents a matter of utmost importance that deserves the court's consideration. And it's a rule, federal rule of Appellate Procedure 35 that demands that the counsel certify this.
Very good. Let's look at these reasons. You list two main reasons about the issues that have never been adjudicated by any court of the United States. It's A and B. And A says that executive branch practice in excess of legal authority by defendant Federal Bureau of Investigation of labeling innocent Americans such as plaintiffs as suspected terrorists without reasonable support for it pursuant to secret criteria without giving them the due process required notice or opportunity to controvert the permanent inclusion in two unauthorized categories of the terrorist screening base, etc., etc. I love the clarity of this argument. Do you have any comments or addition to this argument?
Well, I just have to say that paragraph took me days to draft because because I wanted to, in a cohesive, it is a run-on sentence, but in a cohesive paragraph, put the knowledge that I've acquired in over a year of work, condense it into, just say it to the court like that, because there is just so much information, but the most important one had to be there because I am sure that any freedom-loving and defending judge, justice will this is going to pop their eyes out, and it's true. Not a single court of the United States has ever adjudicated the controversy that we are presenting, and that's one of the reasons why it's so important that they do.
Yes, and this is why I applaud your level of clarity that you've been working for it over a year, and this is the paramount of your arguments. They're so clearly distilled that anybody can understand, and especially the Fifth Circuit judges. This is as clear as it gets, and your ability to put this together is simply superb. So thank you, Anna.
Thank you. Thank you.
And let's look at the argument B. This case is the first to ever tackle the government defamation in violation of the Privacy Act resulting from defendants' distribution among 18,000 law enforcement agency, over 532 corporation, 1,440 organization, in at least 60 countries through the National Crime Information Center, or NCIC. Of the TSDB's two secret categories, that label non-terrorists such as plaintiffs as suspected terrorists. I love how it's linked to the first argument, but also shows just another aspect of it. Do you have any comments about it?
Yes, because look, even if assuming the program didn't exist, assuming that there was no targeting, the mere government defamation of calling innocent people that they know they're innocent because they don't get screened additionally when they travel, people that they know that they're not terrorists, being labeling them and spreading it all over the world. And I have to say, this information we got from the discovery in the El Haiti versus Cable case. However, I believe that from information that has come in the news, that 532 corporations, now it's up to 600, they feed directly information through a portal to the FBI of suspicious activity. Yeah, Ana Toledo was here and she ate a hamburger. That's the suspicious activity. But all these corporations that are the largest in the United States feed information as, you know, insignificant as she was here and had a margarita to the FBI portal. But I put the information that I have the evidence of, which is those 18,000 law enforcement organizations and corporations.
Yes, you're very precise. You connect your statement with the evidence, and you're very precise about it. Unlike the defendants who simply misrepresent what our pleadings are saying, just point blank. Or they either misrepresent or ignore. And that's the difference between the work you're doing and the government defendants are doing. So let's go further. In that summary calendar from March 8, what the panel of 3 judges said, Calverts and Stewart detailed pleadings regarding how they discovered their placement on the TSDB exceeds some criteria, yet the panel discarded their allegations because they have not seen the list, curtailing plaintiffs' due process right to discovery. This really got my blood boiling because they're either ignorant about the Glomar response or they're deliberately want to our case to be thrown out or dismissed or something. Is that your impression?
No, look, I really think honestly that what we present, you know, in the lawsuit is so detailed, is so atrocious. No person wants to believe that this is going on. And it's taken me a long time to understand this, because when you think about it, Len, that our government is doing this to its own citizens, it's just very hard for somebody to accept, you know. And the government usually has a presumption that they're not going to be deceptive. You know, they're going to, at least for the courts, you know, they're not going to come to the court, because in federal court you have, for example, Rule 11. Rule 11 tells you you cannot sign a document containing lies. And I take that very seriously, you know. But in Federal Rule 8 demands that the pleadings be very concise and factual. You cannot say it's not just, you know, things that I believe that I was set up. No, it's like, you know, it has to be factual. It cannot be speculative. You see, the pleadings and the pleadings in our complaint are not only factual, but based on uncontroverted evidence that comes from defendants themselves. So saying that, you know, that's what the district court said, that plaintiffs Stewart and Calvert, who have evidence told to them that, you know, they were on this list, well, it is sufficient for the pleading at this pleading stage. They have a right to discovery. They have a right to jurisdictional discovery to find out if they are on the list or not. And that's one of the arguments we're including at the end.
I understand that. To me, I understand your legal point of view. To me, as a non-legal person, as simply a plaintiff, to me, this sounds like hypocrisy. But that's not your professional opinion. Let's let it be a part of the record. So this is a beautifully put paragraph. The crux of this case, if you look at the totality of our pleadings, at all the issues that we are complaining about and all the evidence we presented, this can be summarized in this paragraph that you wrote. Defendants FBI's refusal to produce plaintiff's TSDB status implies an admission that plaintiffs appear on the TSDB handling code 3 and 4, object of the crux of this case. If none of the plaintiffs appear on handling code 3.4, defendant would not have opposed the discovery. Its refusal to do so speak volumes. I love this paragraph.
We asked for a Privacy Act request before filing the lawsuit, but
Correct.
we asked for limited discovery of the TSDB status when they started going, this is a fantastical case, and we're going to see that it's going to get dismissed. That was early on before they filed their motion to dismiss. That's why I filed a motion to compel. And it's very simple. If none of the plaintiffs were on the TSDB, FBI would go to the district court, show the TSDB and say, look, check that they're not here. They don't have to see it. Check, they're not here. Dismiss this case. And there wouldn't even be an appeal. They would have just totally killed the case there. But they don't do it because the plaintiffs are in handling post 3 and 4. And we know that because they let them travel. Plaintiffs can travel freely without being subjected to the problems that people on the watch list, which is handling codes 1 and 2, undergo when traveling.
Yes. And then they say, well, you don't really know whether you're on the case because you haven't seen the list. Of course, we haven't seen the list.
We'll never see it until we get a court order to see it. And here's the thing. A plaintiff does not have to come to court with suitcases of all its evidence. That is the purpose of discovery. And that's why the pleadings of Calvert and Stewart are so crucial to establishing the standing, the injury. In fact, that gives way to discovery. So that's what we're arguing, that, because they are detailed. I mean, Calvert's pleadings are detailed. He's on the floor dying of a blood clot in his lung. And the Brasaria County deputy sheriff comes in and says, we were told a suspected terrorist lived here, and we have to, and these are the terms, secure the premises before we let the ambulance in. That far exceeds the requirements of course, that's for the court to evaluate, right? But it is our contention that exceeds the requirements, the pleading requirements to establish prima facie the case about, I am illegally listed on a terrorist database where I shouldn't be listed.
Correct. And this is what we will be arguing until we cannot argue anymore. But the fact that they consider this case unappealable, it just rubs me the wrong way. There's absolutely no reason for that. Their refusal to show us the list in camera, in the judge's quarters, which has been done in other cases, it speaks volumes. I agree with you.
They say that it's not unappealable because there's not a judgment, because what the district court was supposed to write a separate document saying judgment. For the reasons contained in the memorandum of an order, this lawsuit is dismissed with prejudice. but the district court didn't do that. And so we argue, there's a rule that says the judgment doesn't have to be in a separate document, and it's contained in the brief as well, in the petition as well.
Understood. So that's all the update that I have. I think I agree with you that defendants have gone the distance to curtail plaintiffs' constitutional rights. They throw every dirty trick in the book at us, and we're fighting back.
I want to say that, cases, for example, Kovac v. Ray is probably, I think, like 5 years old, and has already been twice to the circuit. Ficre, FBI versus Ficre, which was argued on January 8th, and the Supreme Court favored Mr. Ficre. Well, that case is 10 years old, has been dismissed twice, has gone to the Ninth Circuit twice. So I want people to understand this, like I said from the get-go, this is a marathon. This is not a sprint race. And so you have to understand that a lot of work, a lot of, that petition has a limitation of 3,900 words. But I have to tell you, I worked nonstop. I have to say over 200 hours doing that, nonstop, obsessed. Even in my sleep, I was thinking about it, because we are, the Fifth Circuit is it's like going to, if you're an actor and you're in Broadway, you're not off Broadway, you are in Broadway. And so you have to do the best you can. And also because there's 6 million people that depend on this. So I just urge the community to understand how much dedication, work, preparation, sacrifice goes into this work, and that we are never giving up, we're never giving up until we're all free.
I just want to add how proud I am to be a part of Target Justice that is making history, and how lucky we are to have you on board, woman 110% dedicated to our legal case. Thank you very much, Anna. That's all for the legal update. Anna, do you have any final thoughts or announcements? Please share with our audience.
Well, number one, the government criminals have been unsubscribing people from the Targeted Justice newsletter. If you have not received emails with newsletters, please verify it. And if you have another email, subscribe with the other email so that you can receive our updates. It's very important you do, because it is through the newsletter that I am going to communicate through the newsletter any updates, and you want to be on top of it. That's one of the things. The other thing is that we're growing the Real Targeted Justice at Rumble channel. For those naysayers, for those people that that may not believe you, there are very good interviews there. That is a good way to say to the person, if you love me, if you care about me, just watch this 45-minute interview. And we don't have to talk about it anymore. But let's continue red pilling people into the reality of this. And the last thing is that contact journalists. We have already evidenced, I have at least 2, James O'Keefe, and Salty Cracker is one of these commentators. He has his own Rumble channel. And he last week admitted he's on the watch list. And he's just because he's very far right. So contact them and tell them you're not just on the watch list, you're a targeted individual. And go to Targeted Justice and read about it, because you can prevent many things from happening to you, and also they can help us spread the word. So I know it was just like final words, and I took all that. But thank you, Lynn, and I am just so happy that you're back, and that we're never giving up.
Thank you. Thank you. And I'm so happy that I gotten this sort of break. For the last two months, I've been basically unable to do any work. And now Sounds like I can take a breather and we can do perhaps shorter podcast. I will start writing on Substack. We have a lot of territory to cover. We have a lot of medical updates, a lot of legal updates. So we're back, at least for now. So I also have an announcement to make that this Friday on April 12th at 12 p.m. Eastern Time, we will have a live event. It's an online symposium called Targeted Doctors. We have 5 doctors who will speak about the experience of being targeted and share their medical perspective. We're planning it to be a regular event, and we are inviting more doctors to step out of the shadow and speak out about it. Doctors are in a very unique situation with respect to targeting because they understand how diagnosis is made and what methods could be used to diagnose it. This event will be hosted by vaxchoice.com and will be live on CloudHub. The announcement, the link will be published on Thursday, April 11th. So follow our newsletter, follow my Substack and a Substack. We will definitely make sure that everybody knows how to link into this live event. And as far as the Targeted Justice v. Garland, the case that we discussed today, I'm amazed but not surprised how much the government defendants don't want our case to be heard in the courtroom. They're using all their influence and every dirty trick in the book. They either misrepresent or ignore our claims. And we expected it going in, but we need your support to continue the fight with the intensity it deserved. And please stop with the defamation. We, as targeted individuals, should know better than this. This is one of the tools the defendants would be using. Please don't fall for it. And we're humbly asking you for donations to the cause and to the legal fight that, without a doubt, will find its way to the Supreme Court. So let's be a part of the history together. See you next time.